across the internet. It usually takes a little bit of time for Facebook to get going and YouTube and Periscope, but once it's live, then we're going to get rocking and rolling today. All right, YouTube's almost there, and it looks like we are live, so let's get rolling. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system, with a hope of encouraging some meaningful change. And we're grateful that you are here and with us today on this lovely Friday. A little bit overcast here in Arizona. Hope you're having a lovely day yourselves. We've got a lot to get into. Of course, today was trial day 5 for Derek Chauvin. Not a lot of activity, if I can be candid about this. We have one more juror, and so we notice now that the pace of jury selection is really slowing down dramatically. We know that on Tuesday we had 3, on Wednesday we had 2, Thursday we had 1, today we got another 1. And so today we're going to talk about who this new juror number 7 is, as well as who some of the people who were disqualified are, because there were some interesting, I think, clips that came out of today's hearings. We also are going to talk about the Minneapolis City Council settling with the Floyd family for a whopping $27 million. And we've got some reaction about that. We've got some things we got to talk about. What are the consequences of this? Because the civil claim now has been settled, and there hasn't even been a finding of any actual criminal liability yet. So many people are saying this is premature. We want to talk about how that might impact the trial and what the consequences of that might be for those in Minnesota and beyond. Then we're going to change gears. We're going to talk about immigration. I've said this before. I think that immigration is probably going to be the next big, crisis or surge or whatever that this country is going to have to deal with on a national scale. It's looking like the southern border is heating up. There are a lot of predictions that this is going to continue to unfold and develop. And so right now we have the Texas Attorney General, guy by the name of Paxton, who is joining a number of other states like Alabama, Arizona, Arkansas, Indiana, and so on, in basically getting into litigation against the Biden administration. Kind of a complicated procedural history here, but we are going to talk about it's essentially a lawsuit talking about this public charge rule. The allegation, the quick and dirty of it, is that when people come across the border, when they're migrating into the United States, if the United States has to care for that person by providing things like housing and Medicare and health benefits, then the question is, does that person become a public charge for legal definitions such that they will no longer be allowed to immigrate into this country? And so they're sort of battling it out over this rule. Interesting stuff from this lawsuit, so we're going to break that down. Then lastly, the final segment of the program is going to be back again about Ghislaine Maxwell. It's been a while since we've talked about her. The last time we were reviewing her case, she was trying to get out of custody again. She filed a third motion for bail, and now we have the U.S. Attorney's Office that has responded. So a lot of her claims were about, well, you just let me out. We're going to put up this $30+ million package. We're going to renounce citizenship for the French and I think England. And the government now responded. And so they're sort of addressing each one of those claims in turn. We're going to break all of that down. Before we get into the show, I want to invite you to go over to locals.com. We have a Watching the Watchers community over there. You can go to watchingthewatchers.locals.com. And if you have a question as we're going throughout the program, feel free to ask it there. Miss Faith will clip it and add it into our slide deck, so I will get to those questions. We will also post a copy of the slides over there as well. If you want to download anything, you can get a free copy of my book. A lot of good people over there. And as a reminder, after the show, we have been jumping off the program and going back over to Clubhouse and doing a little bit of discussion, a little bit Q&A, and sort of getting to know one another on the Clubhouse platform after the broadcast. So stick around for that. It's an iPhone or iPad, iOS only application at this point in time, but the description has the link to the Clubhouse room. So as soon as this broadcast is over, we're going to head over there. If you are able, then please join us. All right, so let's get into the news of the day. Today was day 5 of Derek Chauvin's trial, and we have a 7th juror who was added to the list. And so we're going to break down, as we have been doing on this channel, the demographics of the different jurors. We also are learning a little bit more about the jurors' ages, and so we added a column on our demographics chart. And so let's go into the story today. This is over from thestartribune.com. It says, day ends with the 7th juror added to the Derek Chauvin murder trial. Potential jurors in the Chauvin murder trial were assembled for a 4th day this week, and one found out Friday afternoon that she will join 6 others already chosen to weigh charges in connection with the death of George Floyd. The court adjourned for the day on Friday. The jury so far, and this is where we get some of the ages, includes one multiracial woman in her 20s. We have one black man in his 30s. We have one Hispanic man in his 20s, a white woman in her 50s, and 3 white men, 2 of whom are in their 30s and another one in their 20s. And so we're sort of assembling our little jury panel here, as we can see. And if you're on Clubhouse, you can follow along. Just go to rrlaw.tv and you can see the slides. So we have a total of 14 seats that are going to need to be filled up. 2 of those are going to be dismissed, but right now we're about halfway there. We've got 7 people, and these are the emojis that you can see representing each of our different jurors. This is the demographics chart that we've been building. As we can see down here, juror number 7 looks like it is a white woman in her 50s. She is a healthcare nonprofit individual, so she's sort of an executive at a nonprofit that services the healthcare space. She's a single mother, high-level executive, and she made a statement during her line of questioning today where she basically was saying that not all cops are bad and that she had a lot of empathy for both sides of what happened here. In other words, this was a tragedy all around, which is something that we've been saying here on this channel. So she joins now other jurors. We can see she is the 2nd female who is on the panel. Number 2 is another female. She's in her 20s and she's a person of color. The rest of them are males. And so we've got 3 white males. We've got a total of 3 people of color. We've got 1 Hispanic, 1 black, 1 person of color, and then we've got a total of 4 white people. And so I know it's so uncomfortable to talk about this racial stuff and sort of categorize people, but this is exactly what the jurors are doing. This is what the court is doing. Everybody's looking at the demographics here because this is a trial that is largely centered around race. And so I'm just showing you what is really going on behind the scenes. This is what everybody is doing sort of on both sides. They're trying to make sure that the demographics are best for their side. And so there's nothing even wrong with that, in my opinion. Prosecutor is going to want basically a bunch of non-white people on the jury. The defense is going to want a bunch of white people on the jury. And that's just the reality. I know it's uncomfortable to talk about, but that's just how these things work. So let's take a look at the chart here that we have organizing everything. We can see that not a lot of new people have been added to our panel. Prosecution really looks the same. Didn't see any new additions or subtractions today. Of course, Eric Nelson and the defense team really hasn't seen any additions or subtractions anyways. So I think we'll probably see this throughout most of the trial. I haven't seen any other documents that have been submitted on the court website showing that anybody else is trying to get on board or join the team one way or the other. So let's take a look at the jurors. So the first juror that was stricken today is a woman who was a recent college graduate. She carefully chose her words and she gave unwavering answers to probing questions. She was asked about her ability to consider only the evidence presented at trial and not just the widely viewed video. She says here, "What I saw as a human that did not give me a good impression. What I saw as a human that did not give me a good impression," said the woman who disclosed she participated in a social justice protest in Duluth in the time since Floyd died. She said, quote, "I just couldn't watch it anymore." Defense attorney Eric Nelson, and I'm going to show you a couple clips from this conversation, followed with questions about her willingness to accept information about policies that guide police procedure and whether she was willing to listen to both sides. She assured Nelson that she would on both counts if seated. After a brief huddle with his legal team, he used a strike and had the woman dismissed. So this is a young college student female. She was very kind of short with her answers, sort of yes, yes, yes. And I'm going to show you 2 clips from this line of questioning. So the first one is him sort of going through. We hear her talk about the clip that she says, "I watched the video. I actually couldn't finish it, and it left me with a negative impression." Then what happens is Eric Nelson goes through some of the rest of her questionnaire, and he's basically detailing out that this is somebody who has been largely involved with these protests, somebody who has very strong opinions about it. Then we're going to kind of skip over. There's a lot of, yes, yes, yes. He's going down and saying, So you're passionate about it. Yes. You participated in this. Yes. Yeah. So it's not really that interesting. But then we are going to get to the final part of his questioning where he's kind of asking her, okay, now in light of all of this, in light of everything you posted, in light of everything you've just said here, in light of the fact that you have legitimate opinions that this was a troubling scene, can you still be fair and impartial? And she says, well, we'll get there in a minute. So here is Eric Nelson from his first clip when he's interviewing this young lady.
In terms of your opinion as to Mr. Chauvin, you indicated that it was a somewhat negative response.
Yes.
Okay. And you wrote, the only reason I chose this and not neutral is due to the fact that it went on so long, the knee, in parentheticals. So can you just explain why did that influence your opinion to the more negative of Mr. Chauvin?
I could only watch part of the video, and from what I saw as a human, that did not give me a good impression.
Okay.
Right, and that's fair. And I don't think anybody who watched the video had a good impression of it at all. And so he goes through and he's really hammering that home. And as I go through these explanations, I'm not making a judgment call on one or the other, but this is the defense attorney interviewing somebody about whether they're going to be fair and impartial to Derek Chauvin. So she's out there now saying, yes, I watched the video, I couldn't even finish it, and it left me with a negative impression. So as I mentioned, then this defense attorney, Eric Nelson, goes through sort of a long history about social media posts and other things. Then we get to this next clip where he's really trying to dial in on this and say, all right, listen, you've got all of these opinions. I know that. That's okay. Can you be fair and impartial? And then we hear what she says. And you just have to ask yourself, as somebody who is sort of listening through this, and just listen to this last clip where she said, it was a negative impression, I couldn't even finish the video. Then we're going to go through and you're going to hear Eric Nelson's sort of a list of everything else that she was involved in. And then, well, you can decide. Here is that second clip.
What do you mean by the need for possible police reform?
Just that.
Just that it could be or may not be?
We need police reform.
Right. I mean, are you open to the possibility that police reform is not needed?
No.
So you do believe that there are some reforms that are needed to be made as a result of this incident?
Yes.
Again, and it's perfectly okay. I'm not, you indicated that you had, in fact, yourself participated in a peaceful BLM protest in Duluth, and you did not carry a sign?
Yes.
And that other people like your cousins, I believe, indicated that they had also participated in some marches?
They were in Minneapolis, yes.
Minneapolis, okay. Why did you decide to go to that protest?
I just felt it was necessary to show my support.
Okay. Your support for whom?
Others who have been affected by similar situations.
Okay. So not simply this particular case.
And this case.
And this case. So again, you have an opinion about this case. You have an opinion about Mr. Chauvin. You have an opinion about the need for police reform. And all of those opinions are you are entitled to those opinions. Can you honestly tell us that you can set aside those strong opinions and judge this case on the facts alone?
Yes.
Yeah, okay. So then he goes and huddles with Chauvin and his assistant. They come back and they issue a peremptory strike. Right? I don't have any issues with anybody having their own opinions, but if you have opinions that I think are so rooted that you couldn't even finish the video, that you watched and said that you already developed a negative impression about the man. Also, you went down and physically protested. I mean, that is somebody who is highly invested in the cause. We also heard her say something along the lines of, do you think police reform is necessary? And he says, well, do you think that it's possible that it may not be necessary? And she says, no, it absolutely has to be necessary. So in other words, this woman sees that there is a problem with the police, went down and marched, was pretty vocal about it. It sounds like with some other people in her community, communicating with them and going and protesting. So that's okay. There's no issues with that. I've got no problems with that. But should she be a juror? Of course not. Of course not. And so when she says, yes, I can be fair and impartial, I mean, that's just sort of, we appreciate your faith in yourself, but as a defense lawyer or as a prosecutor, when you have somebody that is that obviously biased one way or the other, they've got to go. So I think that was a very good peremptory strike. And so that was one strike from the defense about somebody who was pro BLM, supported a march, somebody who was anti-police. And the prosecutor today also used a peremptory strike on somebody who was the opposite of that, right? Exactly what we expect. So both sides are using peremptories appropriately. We have another one. This individual was stricken from the jury. The prosecution, according to the Star Tribune, exercised one of its strikes and dismissed a prospective juror who served in the Army Reserve for 8 years and was deployed to Iraq. He was questioned extensively about whether he could give equal weight to testimony of police officers versus bystanders at the scene. Quote, he said, being in the military, it's easy for bystanders to say how they would react in that situation, the man said, while insisting he would not give law enforcement an edge in credibility. He said the fact that Chauvin also served in the military would not affect his opinion, which is, okay, right, that's his statement, but there's sort of a special kinship that exists in the military. We all know that. The man also attributed to witnesses some of the growing tension and stress in the atmosphere as Floyd was being restrained. He said, quote, it seemed like it escalated very quickly. He said, people yelling, people recording, all the while police are trying to retain control of the situation. And so the prosecution struck him out as well. And so another good peremptory strike. This is somebody who is, much more law and order, Army Reserve. He was somebody who was there for 8 years, deployed to Iraq, knows chain of command, knows protocols, and they booted him, as they probably should have. So again, both sides exercising peremptories appropriately. Then near, midday, we got the seventh juror who made it onto the panel. And we're going to learn a little bit more about her, and then we got a clip from her as well. So here she is. The seventh juror seated is a single mother who is a high-level executive in the nonprofit sector focused on healthcare. She took the unusual move of summoning her own attorney to the courthouse. At one point, the judge halted the live external feed, cleared the courtroom of everyone except the trial participants out of unspecified privacy concerns. She told defense attorney Nelson that she had prior professional dealings with Attorney General Keith Ellison's office. They're running the prosecution in this case, but didn't know him personally. She later told prosecuting attorney Steve Schleicher that, quote, all of our interactions with Ellison were positive at the time and would have no impact on her ability to be a fair juror. The woman said the bystander video left her with somewhat negative view of Chauvin, explaining that, quote, a man died and I'm not sure that's procedure. Not all police are bad, but the bad behavior police need to go, which is very reasonable, I think. At the same time, she acknowledged sympathy for Floyd and the officers at the scene that night, saying, quote, everyone's lives are changed by this incident, and it's not easy for anyone. She was followed by the next prospective juror, a young woman who was quickly excused, saying that she got a new job and she was attempting to move. So some jurors are just being sort of booted out just because of practical concerns. I've got a job, I'm attempting to move. We saw, I think one of the jurors who was seated actually had a wedding coming up in May, but he's going through this anyways. He got a little bit of a motion to continue granted on that wedding, which is, it might be a good thing for him. So let's take a look at juror number 7 and his or her conversation here with attorney Eric Nelson. Here it is.
What you wrote in terms of the opinions you expressed to your friends and family, at least, was that you had sympathy for Mr. Floyd as well as the officers.
Mm-hmm.
Can you explain that a little to me?
Everyone's lives are changed by this incident and what happened. Everyone's lives. And it's not easy for anyone. And so, yeah, I have sympathy or empathy, for everyone involved, because this is life-altering, life-changing, and it's hard.
Okay.
Yeah, and I think that's very reasonable. And it's sort of funny to hear how people respond to those questions. If you recall, when juror number 2 was up, I think that was on Tuesday, she came out and she's like, I'm just so excited to be here. Oh, I can't, this is going to be crazy. And, she was a college student and she knows how important it is. And so she made it onto the jury. And you sort of compare and contrast that to juror number 7, who's like, oh, gosh, this whole thing is just a mess. And so you've got people from multiple different age groups. We have a 20-some-year-old woman. We have a 50-year-old woman. We've got men sort of scattered around the age brackets. And so we've got a lot of room ahead. We've got a long ways to go until we get a full panel. We can see here, we go back to our emoji panel. We've got number 8. So let's say we get number 8 on Monday. We have number 9 Tuesday, 10 Wednesday, Thursday, Friday, Monday, Tuesday. So we could have a week and a couple days potentially, or if they're able to kind of squeeze some of these things together, if we can get 2, 2, and maybe 1, we could finish up next week. That would be 4 days. But there was another issue that we talked about yesterday where there are still motions in limine that they need to solve. And remember, motions in limine are the sort of the rules of the trial. They have to sort some of those things out. And yesterday, they discussed that today they were going to, both the defense attorney and the prosecution was going to be delivering USB drives over to the judge. And they granted the judge time over the weekend to review everything so that when they come back on Monday, the judge is up to speed with all of the things that they're going to be talking about. And one of those was a pretty critical issue that relates to the 2019 case where George Floyd also had an interaction with law enforcement. And the defense allegation here, the reason why they want to talk about that case is because they're saying his modus operandi was all about anytime he had interaction with law enforcement, he would just consume whatever drugs were on his person. So they want to bring that 2019 case into this current trial and explain that this is something that he did or he likely did because he did it historically. And so the judge obviously knows how provocative that is. It is extremely, extremely prejudicial. Is it probative enough to overcome that prejudice? Well, we don't know. And so the judge is going to get up to speed about those issues over the weekend, and then we should hear more about that on Monday morning. So Monday may not have a lot of jurors selected because of those other preliminary issues are going to be dealt with first thing. So we also know that today there was new news that there was a $27 million settlement with the George Floyd family. Massive, massive settlement. This article, again, over from Star Tribune, written by Liz Navratil and Maya Rao, says Minneapolis will pay the record $27 million to settle the lawsuit brought by the Floyd family. Largest pretrial settlement in a civil rights wrongful death case in history, said Floyd's attorneys. When George Floyd was horrifically killed on May 25th, it was a watershed moment for America, said family attorney Ben Crump this afternoon, Friday, at a news conference. Quote, he says, it's one of the most egregious and shocking documentations of an American citizen being tortured to death by a police officer, one of the worst ever witnessed in history. History will judge us for how we respond to this tragedy, for how we responded to this tragedy. Crump applauded Mayor Jacob Frey and council members for the settlement, saying Minneapolis was being watched in its darkest hour. Now the city can be a beacon of hope and light and change for cities across America and across the globe. After a roughly 40-minute private meeting Friday afternoon, city council members voted unanimously to approve the settlement. Frey's office said he will approve it as well. Of the $27,500,000 will be used for the benefit of the community around 38th in Chicago, where Floyd died, according to the city. So the rest of that money sounds like $27.5 million going back over to the Floyd family. This is a deeply traumatic event, unfortunately, is a part of too many Black and brown families' realities, said Council Vice President Andrea Jenkins after the vote. There is no amount of money that can replace a brother, a son, a nephew, a father, a loved one. But what we can do is continue to work towards justice and equity and equality in the city of Minneapolis, and that's what I commit to do. The settlement could have major implications for the city and its police department, whose fate hangs in the balance as some city leaders and community members seek to replace it. And we know that because they originally defunded the police. I think they moved $8 million out of their budget into another budget, and then a couple months later, they put back $6.3 million, so they refunded the police, and we talked about that here on this channel. So now we've got $27 million that is also coming from city funds. I don't know if they have special funds there or where that's coming from, but that's a significant chunk of money. If we recall, they defunded the police, I think it was about $8 million, and now they're sort of paying out $27 million, which is a nice chunk of change. The previous record for police payouts came in 2019 when city agreed to pay $20 million to settle the lawsuit filed by Justine Rusiek Damond. She was killed by former Minneapolis police officer Mohammed Noor after she called a report a possible assault in an alley behind her South Minneapolis home. And that's the second time we've heard about this case, the Noor case. You may remember that was basically the underlying case that was the subject of Chauvin's appeal regarding the third-degree murder charge that just came back. I think that was Tuesday. Here is the motion. Here is the formal settlement agreement. We're going to hear from George Floyd's attorney, his family's attorney, in the next slide. But this is the final settlement offer that we got out of the city today. Motion: Goodman moves to approve the settlement of all claims asserted by Karen Nelson Schaefer, plaintiff, as trustee for the next of kin of George Floyd Jr., instituted legal proceedings against the city of Minneapolis and U.S. District Court, payment of $27 million to the estate of the next of kin of George Floyd Jr. via persons or entities as determined by the court's anticipated distribution from fund/org. Of which $500,000 will be used for the benefit of the community around 38th and Chicago, and to authorize the city attorney's office to execute any documents necessary to effectuate the settlement and the dismissal. So very, very, very large settlement. And here is Ben Crump, George Floyd's family or his estate's attorney. And you'll notice, I mean, he's calling for peace right out of the gate. This clip came over from CBS on Twitter. Let's listen in.
Let's follow George Floyd's example in being peaceful as we stand up for justice. Can we all do that? Can we all do that for George Floyd? Can we all do that for our children? It is my great honor to announce that George Floyd's family, our legal team, and the city of Minneapolis and its leaders have settled the civil lawsuit in the death of George Floyd. The settlement is not just historic because of the $27 million paid out, but for the impact on social justice, policy reforms, and police.
All right, so it obviously is a big settlement. Family is going to be very, very happy about it. We've got a statement over here on Twitter this was from Aaron Hesanyanda, WCCO, says, this is a statement from the Floyd family on the settlement. It says, our family is grateful for all those who care so deeply about George's life and our loss, and this agreement is a necessary step for all of us to begin to get some closure, said Rodney Floyd, brother of George Floyd. So get some closure. We'll see, because the trial is still another, 6 weeks out from getting resolved. It may be even longer than that, maybe 2 months. But I have some initial thoughts on the settlement agreement. So, a lot of people out there are saying, a lot of opinions being expressed right now. So let's break this down just a little bit. Let's look at the pros first. What might be good things that come out of the settlement? Well, number one, George Floyd's family gets compensated for this, right? They lost somebody, a brother, somebody close to them, a son. The whole family's impacted. Obviously, we want to make sure that they're taken care of and receive some compensation for their loss. That is a good thing. It could be a not good thing if you're on the other side of this conversation and you're saying, yeah, but wait a minute. He didn't die because of anything that the city did. He died because of a drug overdose. And they haven't even gone through and proven criminal culpability. There has been no proof of causation that Derek Chauvin ultimately resulted in the death of George Floyd. That's still up for debate, and you can have a reasonable disagreement about that. Right now, it's undecided because the trial has not been had yet. And the city council came out and settled the case before any liability has been proven. And so you can understand that these are two separate, I would say, burdens of proof, two different standards that we're talking about here. Criminal court is a much higher burden. It's a much higher standard. It's called beyond a reasonable doubt. And so you could say that maybe the defense can show that there's enough doubt that's based in reason as to whether or not the knee killed George Floyd, or whether it was some other substantial factor like drugs or like heart problems or like recovery from COVID. You could have that perspective on it, but that's for a criminal case. So if you can show that there is some doubt that's based in reason, well, maybe he doesn't get convicted in a criminal court because that burden of proof is so high. But in a civil claim in a civil case, think about the standard being significantly lower. So beyond a reasonable doubt, when we talk about it in terms of percentages, we kind of say it's an analogy, but kind of say like if it's 80% likely that a person committed that offense, we can find them guilty. Like 80%. It's a high threshold. But for a civil case, it's low. It's closer to like 51%. If it's more likely than not, it's a much lower standard. And so you could see where you might be able to show that George Floyd you can't prove it beyond a reasonable doubt that he was killed by Chauvin for criminal court, but that maybe he was a substantial factor and it was a major contribution to his death in civil court. So you can sort of flesh out those arguments either way. Another thing, I think a pro here is that the city council is obviously responding to their constituents. Now, I don't live in Minneapolis or Minnesota, don't really even know anybody out there. I think we have a couple people in Clubhouse, or I think one or two people who are in that area, and they were sort of detailing what the feeling was on the ground. But you have to understand that the city council, they probably have a lot of constituents who are very upset about this, and they've got to make a policy decision about how to handle this moving forward in a way that's going to cause the least amount of damage to the city. Let's say, hypothetically, that this settlement goes through and Derek Chauvin is convicted on all counts, and the city feels like the civil compensation matches the criminal conviction, and everything is well and good. We're all hoping that there's no unrest, that there's no riots, that everybody's happy with that. But in the event that that does not happen, in the event that Derek Chauvin is acquitted on all counts, or he's sort of splits down the middle, maybe he's convicted on 2, not convicted on 1, or convicted on 1 and not convicted on 2, then what happens with that? Does that invalidate the settlement? What if he's acquitted on all counts? Does that invalidate the settlement? Well, no, the city already entered into this agreement. They're going to pay it regardless of his acquittal. But how does that sit with the public in terms of the public's paying for that, right? The public is compensating the family for that. And I know it feels just awful to talk about money in the context of losing somebody's life, but this is a policy consideration. And this is something that irritates me so badly when it comes to our police departments and our law enforcement agencies throughout this country. They're able to go out there, kill people and break things. And guess who pays for their negligence? We do. All the people do. Where do you think that $27 million is coming from? It's coming from the taxpayers. It's going into some coffers that the city council just kind of allows their police to do whatever they want to do, and then they pay damages for the harm that their police caused. And so maybe this is, if anything, this $27 million is just a nice little slap in the mouth for all of the policymakers in the state government, the federal government, that say, hey, pull your heads out of your rears. We want actual reform. And until you pass that stuff, we're just going to keep slapping these massive fines on you, or we're going to settle these massive claims until something gets done. So we've got a lot of policy things to talk about. The big question here is this going to be enough to calm the storm, to sort of turn the volume down here? We heard from Ben Crump saying that peace, 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 please, please, please. And of course, I think that settlement makes it a lot easier for him to say that, doesn't it? Right? He just settled a $27 million claim. He's going to take a big chunk of that for his fee. And now he can come out and just say, yes, now it's peaceful. Right. All right. So let's take a look at some of the questions over from locals.com. We've got Liberty or Death in the house. Says, spring break, no class for a week, taking it easy tonight, no studying, hit it again tomorrow afternoon. You have my undivided attention. Mrs. Liberty or Death is watching too. She thinks you're funny and cute and know your stuff. Please give her a shout out. What's up, Mrs. Liberty or Death? We love having Mr. Liberty or Death on the program. Very insightful, lovely comments. I think he's going to be a powerhouse in the future. So you made a good decision. We have News Now Wyoming says, Court TV today said this summer Chauvin was offered and accepted a plea agreement for third-degree murder, but AG Barr nixed it. Yeah, we talked about that here on the channel. I was confused, so I looked at 20 articles verifying the claim, but none of them explained why AG Barr had any say on state criminal charges. Would he be able to stop a state settlement? So I don't think that AG Barr would have any ability to sort of get in there and interfere on a state settlement. I think that the original reason why that plea agreement was not sort of resolved back then is there was a possibility that there were federal civil rights charges that would be brought in a district court. And so, of course, if that is in a district court and the U.S. Attorney's Office is going to be responding to that, AG Barr did have jurisdiction over those claims. And so I think they were, as part of the settlement, the family could have filed suit in state court. They could have filed, I think, civil rights claims under federal code, and that would have extended jurisdiction up into the federal courts. And so he was just brought into the circle to discuss the possibility of a global settlement. And obviously that didn't come to fruition. This was settled, looks like, in state court. There were no federal claims that were filed. I'm going to guess that as part of this settlement, they are going to be waiving the potential of any other federal claims that they would have otherwise maybe been able to bring. So, again, and the plea agreement thing, that's a little bit of a question. That's a problematic issue here as well. The idea that Derek Chauvin would have pled guilty to a murder charge and that's being floated around the media like he was contemplating to accept guilt on that, that is not good, right, for a defendant to say, well, he's sort of predisposed to pleading guilty. That sort of presumes that he thinks he is guilty and that he actually did something wrong. And so it's sort of going against the grain of the presumption of innocence when that is being floated around. Now we also see that there was a settlement that took place that is sort of implying that the city did something wrong before that's even been proven in a court of law. So it is, another thing that is just sort of framing this out as thinking beyond the sale. It's, we've already basically convicted him in the court of public opinion. And now the city council has done so as well by just acknowledging that they are responsible for harm, a lot of harm, $27 million worth of harm before it's even been discussed in court. Now, it may go through court. He may get convicted on all three charges, and the city was 100% right. But what happens if not? What happens if all of the evidence is presented and the city just paid out $27 million? I'm not saying that's not justified, but if they're going to pay the $27 million out on the basis that a city employee murdered somebody else and the court of law finds that he didn't actually murder somebody else, well, then the basis for the settlement of $27 million suddenly looks a lot less grounded, doesn't it? Farmer's daughter number 4 says, Robert, good evening. Do you think the $27 million settlement will affect the results of the trial? Thank you. I would hope not, right? It shouldn't. The jurors at this point in time, at least the 7 who have been seated, they shouldn't hear anything about it. Do you believe that they're not going to hear anything about it? I don't. I really don't know. I don't think it's a good thing. I don't think that this was something that should have happened before the verdict, but you can speculate all day long as to why they decided to do that. I don't know how it's going to go yet. People are asking me about my predictions on this, and it's hard for me to comment on that because it is all speculative at this point. No evidence has been presented yet. We have hints of the evidence. We kind of know where the attorneys are going based on their lines of questioning, but we just haven't seen anything presented in court yet. So I would just be purely speculating. We have Hack Consulting says, hey, if they want to make race an issue, we may as well talk about it. We may dislike identity politics. However, we should find a way to be anti-identity politics. I am okay with the settlement. George did die. Now his family has a boost that surely George is happy for his family about. Less moral argument for the rioting. Yeah, I mean, look, I don't have any issues with the settlement either. I mean, I think it's something that it's a local issue. If the city council thinks that's best for their city and they entered into settlement negotiations with the Floyd family, they're free to do that. I just think that it might be a little bit premature because we haven't actually settled on the issue of causation about death or whether Derek Chauvin was ultimately responsible for it. Everything up until this point is just speculation. And understand that the presumption of innocence is still in effect in this country as far as I can tell. And so Derek Chauvin has not been convicted yet. He's still innocent. I know people don't think that, but this is the legal standard in this country. And I get on here and I rant and rave about it because it is that important. It's not something that we can just overlook because of the heinousness of the crime. Andrew Cuomo deserves it too. So does Ghislaine Maxwell. We're going to talk about her later. But everybody deserves it because that is the basis of our justice system. We start out not guilty. And so when you start to see dog piles happening around this country where everybody's just chomping at the bit to start declaring people guilty for whatever reason because they don't like the nature of the offense that's being alleged, that's not okay. They're entitled to their opinion, but they're not entitled to be jurors and they're not entitled to interfere with due process as it should exist to ensure that we have a fair and impartial trial. Good comment there, Hack Consulting. We got CA Java Bean says, if defense hadn't used peremptory challenge, would judge have dismissed for cause because of her obvious desire to be an activist juror? So I don't think so, actually. I think that judge would have allowed her to be on because of the fact that she said I could be fair and impartial. This judge maybe would have stricken her for cause, but maybe not. I mean, I've heard this judge a few times say, well, they said they could be fair and impartial. And if the prosecutor would have argued about it, well, they might have kept her, but I think that she absolutely should have been struck. And that was a good peremptory move and good question, CA Java Bean. We got the doctor in the house. We have NY Renal MD says, does the juror have standing to allow her own lawyer to address the court? Why is this allowed? Is this typical? It's not typical, but yeah, I mean, if she's being summoned into court, she is a citizen that has the same due process to be represented by counsel in formal legal proceedings. So I don't think that it is customary. I think this woman was sort of a higher up position in a major healthcare nonprofit company. And so it sounds like she had the resources to bring somebody in. There was some questions about a conflict of interest or about being too close because of the business that she did with Keith Ellison in his office. And so, she was just exercising due caution. Attorneys will sometimes get involved in jury duty, but typically not. I mean, I've never been involved in anything like that myself. We have Ma Fox says, it's pretty clear to me this woman is pretty important if she has the money resources for an attorney to represent her as a juror. Yeah, I think you're exactly right. Somebody who just, let me get my lawyer on the phone, and he's there. And so, I'm not sure how you can read into that, but it does sound like she's in that upper echelon. We have News Now Wyoming said, I just did a video on the same article. I was very confused about the phrase, we will be judged forever for our reactions to this tragedy. Why? What are we being judged for? Looting and burning or a $27 million settlement? Is that what we are doing to settle it? Well, I don't know. I don't know specifically. I can't speak for that gentleman. We will be judged forever for our reactions to this tragedy. And, I don't know. I mean, everybody's using a lot of very, very colorful language right now. I mean, truthfully, as far as I can tell, we're doing in my opinion, a pretty good job, I think, of moving the needle on this issue. We've seen the Minneapolis City Council already make some major reforms. We see that George Floyd family just got $27 million. We are prosecuting the police officer who's responsible for it. And so I don't know what else there is to do on this particular case. Now, there is a lot that we can do to make sure that this stuff doesn't happen again. That conversation is not over. So maybe they're talking about that. And we've got a lot of runway left on this case. Farmer's Daughter says, do you think this settlement will set a future precedent for lawsuits? I do. I think that you always have to think about incentives when it comes to these types of things. And yeah, 27 million is a lot of money. That's going to create a lot of incentives. And I don't know what that means necessarily. Whether that causes people to want to file more lawsuits against the city, or whether the city suddenly starts sort of pulling back from certain types of enforcement because they don't want the liability of having to pay for certain types of claims like this. I don't know what the police budget there is in Minneapolis, but I would imagine that $27 million is a big chunk of that. And I'm not sure where that money's coming from, but somebody's got to pay for that, right? The city's got to deal with that, and that's not insignificant. And so the city might have some disincentives to do certain things that might result in something, right? Unknown consequences. We don't know. But the question here is about incentives, I think, and other people might be suing for bigger claims. Other people might be provoking certain interactions with law enforcement. It's just speculation. And law enforcement themselves may want to withdraw from certain types of enforcement so that they're not exposing themselves to a big settlement. This is all speculation. We don't know, but certainly I think it's a good question. We have Liberty or Death says, still haven't seen proof that Floyd was targeted or that Chauvin kept on his neck, if that's what killed him, was sure to racism. I can't stand Crump. He is one of Dr. Thomas Sowell calls a race hustler. Oh, does he? I didn't know that. He is going to get 1/3 of that 26 and 1/22 million. 26.5 million. Yeah, he's getting a nice payday. He's getting a very nice payday. That was a good case for him to settle. He settled. He's going to make a very significant chunk of money. We have Dr. Renal MD from New York says 27 million is just a start. There is an autonomous zone insurrection underway. That city is done. How does anyone return to life as usual? Who will invest in a business or home there? I fear the city is another casualty of the culture war. Democrats are angry about January 6th. Are they worried about destruction of a city? Well, I saw that not in Minneapolis yesterday. First of all, I did hear about that autonomous zone. I actually heard that somebody was killed in that autonomous zone very recently in the area surrounding Floyd's death. And there was also a video late last night that they set Portland's courthouse on fire. I saw literally the side of the building was on fire, and they went out and they extinguished it pretty quickly. But it is very interesting, isn't it? Right? January 6th was something that we are still getting beaten over the head about: extremism, white supremacy, and on and on and on. But almost no news about what's going on in Portland, and that is actually throwing Molotov cocktails and incendiaries at federal court buildings. So you can see what the double standard looks like in the media. Just get used to it. I don't think that's going anywhere. All right, so good questions on Derek Chauvin. Thank you for those. Those all came over from locals.com. We have a Watching the Watchers community over there. So if you want to get involved in the show, that's where to do it. All right. So we're going to change gears. Now we're going to talk about immigration. We haven't talked a lot about immigration. There is a new legal kerfuffle going on here between Attorney General of Texas, Ken Paxton, and the Biden administration. So this is an interesting case I want to go through. It's surrounding this idea, this concept of what's called a public charge. And a public charge is sort of the idea that if somebody comes into this country and they're not able to support themselves, if they can't find a place to live or food to eat or a place to get medical care, they can't find a job, well, whose responsibility is that to care for that person? Well, it's ours. It's society. We don't want people to be dying on the streets, and so we all got to care for them. But when it comes to immigration law, they have to consider these issues because resources are finite. And the question then becomes, when people are trying to immigrate into this country, is there some sort of analysis that is going on to determine whether or not these people will ultimately be public charges? And if so, what do we do about that? And so very interesting sort of procedural history here. Let me show you this document. This is being submitted into the U.S. Court of Appeals for the Fourth Circuit. And you're going to notice that this is Casa de Maryland versus Joe Biden. All right, so it's a private company as plaintiff suing Joe Biden. Well, what's interesting about this is this originally was against Donald Trump. Okay, but Trump didn't win re-election, as we know, and so Joe Biden is now in office. So this originally goes back to a prior rule where the Trump administration was trying to decipher and sort of define what a public charge was. And so they defined that. Then they got sued because nobody liked that definition of a public charge, or at least, some obviously a lot of people did. They're being sued to bring back that definition, but Casa de Maryland did not like that. They sued the Trump administration over it, and there was a back and forth. Trump is not in office anymore. So now the lawsuit is against the president. So now Joe Biden is the president. But now Joe Biden doesn't want to enforce the Trump rule that the original lawsuit was about. So Biden and the plaintiffs are now kind of on the same side. The plaintiff was suing. They didn't like the rule. Trump's not in office anymore. Joe Biden comes into office. Joe Biden says, we don't like the rule either. So that rule is going away. So now because the defendant and the plaintiff are kind of on the same side, they both agree that they don't like the rule. The court just said, all right, we're going to go ahead and dismiss the case because there's nothing to argue about anymore. And now Attorney General Ken Paxton is saying, hold on a minute. You didn't consult with any of us. This is an important issue. We rely on that rule. We rely on it for our law enforcement budgets. We rely on it for our immigration enforcement. We are planning our cities around this. And you're just going to dismiss this debate that's going on about this rule and not hear from any of the states that it's ultimately going to impact. You're just going to let the executive come in and just modify things that's going to have adverse impacts on our various states. So Ken Paxton is now appealing this up, and they're seated in the Fourth Circuit. So let's go through this. I want to show you how many states are involved. It's a big deal. We've got Casa de Maryland, local disclosure statement. None of this stuff really matters. Look at the states over here. We got Texas, Alabama, Arizona, Arkansas, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Montana, Ohio, and Oklahoma. So we've got a lot. We've got state of South Carolina and West Virginia, all joining in on this lawsuit. And so some of these are border states, obviously, Texas, Arizona, we sort of here on the right on the southern border, and others are in the southern United States. And so they're seeing some of the impacts of immigration. We're going to go through here. Let's take a look at the introduction. So all of these states are seeking to intervene in this case. They want to get involved. So they were not originally involved, but they want to intervene. They want to defend the duly promulgated rule that is interpreting the Immigration Act's prohibition against immigration by those who would become a public charge. So in other words, if you are somebody who is trying to immigrate into this country and you are going to be a public charge, according to the Immigration and Nationality Act, those people are going to be barred from entering the country, right? They're not going to be in here. 2 days ago, the named defendants, so that would be Joe Biden, who are agents and agencies of the U.S., they filed a stipulated motion to dismiss, which means they agreed with the people who were filing the lawsuit. Biden agreed with Casa de Maryland, and they stipulated to dismiss the case. The court granted that motion, and then it issued its mandates without offering the affected parties, which are the states, any opportunity to seek to defend the rule. So they just made a decision on their own. They didn't talk about anybody else that this might impact. The rule that they are now seeking to revise directly implicates the state's obligations in providing Medicaid and other social services to indigent and low-income individuals. Moreover, the states, especially border states, have strong interest in enforcing the rule, which properly interpreted and implemented Congress's long-held policy of immigrant self-sufficiency. The request is timely because this court made its mandate just 2 days after the United States announced it would no longer defend the rule. Interested parties had no ability to intervene before it did so. So the president, Joe Biden, and his administration just said, yeah, we're not going to defend the rule anymore, so dismiss all of the claims. The United States did not inform the states that it intended to cease the rule or cease defending the rule, and states did not have an opportunity to even get involved or to say anything. It goes on. A little bit of background here. Let's look at the U.S. Code. So this is 8 U.S. Code 1182A4A, and it says here, under federal law, any alien who, in the opinion of the Attorney General at the time of application for admission or adjustment of status, is likely to become a public charge is inadmissible. The immigration case concerns the hotly contested public charge rule. So if they are a public charge, they are inadmissible. And this is existing U.S. Code, 8 U.S. Code 1182. So the question here is, how do we define this term? What is a public charge? You can see here the definition is pretty clear. It's likely to become a public charge is inadmissible, or the rule is clear, but we don't know what a public charge is. So the Trump administration tried to define that. Here it is. In 2018, following extensive notice and comment, Department of Homeland Security issued a final rule adopting the definition of public charge. What does it say? The new rule says a public charge is, quote, an alien who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period. So what does that mean? If over 3 years, 36 months, you accumulate more than 12 months of, let's say, government support, public benefits, doesn't matter. They don't have to be, it sounds like they don't have to be consecutive. So you don't have to spend a year on public benefits. But if you just spend, let's say, January, take February off, get a temporary job. Oh, you need public benefits in March. But in April, you get a job, you have some side work, and on and on and on. Well, you add up those different months. And if you, in the aggregate, accumulate 12 or more within 36 months, then you don't get to be considered admissible into this country. The rule further explains public benefits includes non-cash benefits that are partially funded by the states, including Medicaid benefits. The plaintiffs here, Casa de Maryland, and 2 individuals, they sued against the president, Department of Homeland Security, and other federal defendants in their official capacities. The plaintiffs allege that the rule violates the APA, Fifth Amendment, going to be due process issues there. They moved for an injunction. The district court granted the motion, and it stopped the federal defendants from enforcing the rule anywhere. So in other words, the lower level district court said, you can't use that rule, Trump. Sorry, it's not going to happen. Not going to happen anywhere. Then the Court of Appeals reversed that. It said it held that the rule rests on an interpretation of the public charge that comports with a straightforward reading of the statute. The panel further ruled the district court erred in its choice of a remedy by issuing a plainly overbroad nationwide injunction. So it goes through the district court. District court says, yeah, you can't do that rule. Court of Appeals says, yeah, actually you can, because it's pretty reasonable based under the statute. Then the plaintiff said, well, now we want a rehearing en banc. So we want the full court to hear it because it was just a previous portion of the court. In Court of Appeals, you'll get sort of a panel ruling where you'll just get 3 judges who issue a ruling, and you can say, well, we don't like that ruling, so we want the entire court to rule on it, which is what they did. The court called for a supplemental briefing to explain what's going on. The defendants here, President Biden, shortly thereafter, let's say the court called for a supplemental briefing. The defendants responded that on February 2nd, President Biden issued an executive order directing a review of the rule, so that the defendants suggested that the court postpone the oral argument until that review is complete. The court agreed, removed the case from oral arguments. Then, March 9th, without beginning the process to rescind the rule or provide notice to the other parties, defendants filed an unopposed motion to dismiss. Court granted that motion, and now they're trying to get involved and say you should not have just eliminated that rule so easily. Because the defendants will no longer defend a rule directly implicating the state's interests, the state now moves the court to withdraw its mandate, reconsider its dismissal, and for leave to intervene in defense of the rule. So all of those different states are now going to get involved, or they're asking the court to allow them to get involved so that they can step in and defend this rule that says that if you are a public charge for more than 12 months of 36 months, or if they can sort of analyze you and consider you to be in that category, then you are not admissible. So why should this happen? What is Paxton's argument? Why should this go into effect? What do the states have to argue about here? says here the court should recall the mandate because it has the inherent power to do so. Extraordinary circumstances justify recalling the mandate where the state intervenors were presented with no opportunity to preserve their interests. Until March 9th, the states were represented by the United States. The United States did not inform the states that it intended to withdraw its defense of the rule. So the states were relying on the federal government to represent the defense of this rule because they're the government. They're the ones who are in charge of that rule. It was a rule that was carried over from Donald Trump. We know that, but it's still with the U.S. government. So if the U.S. government is going to abandon the defense of the rule, shouldn't the states who are relying on that rule be notified about it? This is depriving the states of an opportunity to intervene prior to its dismissal. Likewise, the court almost immediately issued the mandate following the motion, and once again, precluded the states from getting involved. This harms the states, which include multiple border states, from allowing the district court's nationwide injunction to take effect are severe, which is going to hamper the state's ability to act in a period of great budgetary uncertainty. The mandate should be recalled. Why? The court should stay the mandate because this is going to be submitted on a writ of certiorari up to the Supreme Court. And it's also going to be likely that the Supreme Court grants certiorari. So we can see here, they're going through some sort of legal case law. You can see here, it says here, the final rule's definition of public charge is consistent with the relevant statute. It's not arbitrary. It's not capricious. And so the Second Circuit has found a similar rule to exceed the scope of the delegated power. Let's go on. It says, this question is vitally important. Decisions about whether and under what conditions to admit immigrants implicate, quote, fundamental sovereign attribute exercised by the government's political departments. So this is one of the primary functions of government, is to control immigration. And so when the federal government is interfering with this, the states need to be notified so they can respond accordingly. Second Circuit noted, saying that making these decisions correctly is essential because, quote, there is no apparent means by which Department of Homeland Security could revisit adjustment determinations. Congress explicitly directed the executive branch to deny admission or adjustment of status to aliens who, quote, in the opinion of the secretary, are likely at any time to become a public charge. It's in the U.S. Code, they're saying. The rule provides key guidance in doing so, issuing formal, objective standards by which the determination will be made. And so they're saying the Supreme Court has already once determined it on the merits. They're saying there's a significant possibility of reversal so that if they actually listen to this case, the states will prevail on the merits because the rule is lawful. For more than a century, they say, it has been the immigration policy of the United States that aliens within the nation's borders not depend on public resources to meet their needs, and the availability of public benefits not constitute an incentive for immigration to the United States. That long-held policy formed the basis of the public charge rule. Congress never defined the term public charge, but, quote, the ordinary meaning public charge was one who produces a money charge upon or an expense to the public for support and care, which sounds like a pretty good definition. It's coming from Black Law's Dictionary, which is sort of the gold standard for legal dictionaries. The rule reflects that ordinary meaning by defining as public charges those individuals who rely on individual benefits for a prolonged period or multiple benefits for a shorter period of time. But Biden just got rid of that rule, just with the stroke of a pen through his executive order. Now the courts are not going to be enforcing it. And so they're trying to appeal this. We got one more slide on this. There is a likelihood of irreparable harm absent a stay. So what happens if the government does not allow the state to get involved, the multiple states to get involved and defend this lawsuit? What happens if the Court of Appeals says, well, no thanks, we already made our decision, we're not going to hear from you? Biden administration already determined what the ruling is, we're going to stick to that ruling. Well, what happens to the states? What's going to be the harm? Is it irreparable harm? Let's look. Here it says, allowing the mandate to issue and permitting the district court to vacate the rule will cause irreparable harm. State suffers an institutional injury from the inversion of federalism principles. When an injunction, the district court's judgment reverses a formal rulemaking process upon which states have relied. So states have relied on this rule for what? Law enforcement and budgetary policies without allowing them input would allow a formal rescission of the process. It interferes with traditional state prerogatives for the reasons described in the accompanying memorandum in the motion. As the court is aware, this is a time of considerable financial strain on all the states because of the pandemic and the economic downturn. Immigration can be a driver of cultural and economic growth, this says, but Congress has recognized for over a century it can also strain the public fisc. By definition, individuals whose receipt of benefits depend on the definition of public charge are among the poorest in our society. Because such benefits can never be recouped, states will be irreparably harmed if the rule cannot be enforced while its legality is resolved here and elsewhere. So what that means is they're saying that we need to issue a stay, keep the rule in place while we're able to make some conversations and make some maneuvers about what to do with our original policy. We've already been acting a certain way. We were already processing and analyzing potential immigrants into this country under this rule. Now you're modifying it. We've already been relying on it to our detriment. And so if you're going to be considering getting rid of it, we at least need to stay so that we can start mitigating some of the harm caused by the abdication of the rule. You can see here, signed off by basically everybody. We have Ken Paxton. We got Brent Webster over from Texas. We have Steve Marshall, Alabama. Mark Bernovich over here from Arizona. What up, Mark? We got Leslie Rutledge. We got Todd. We got Derek Schmidt from Kansas. Daniel Cameron from Kentucky. We heard about him in the Breonna Taylor case. Not a fan. We have Jeff Landry, Attorney General, Louisiana. Lynn Fitch, Mississippi, Montana, Ohio, and others. So interesting case here. Now, Attorney General Paxton is also going after the masks. So he's going after Biden on immigration, and he's going after his own state, Austin, the city of Austin, over mask mandates. So here he is. This article comes over from hotair.com. Says Attorney General Ken Paxton threatened to sue the city of Austin on Wednesday over the city's continuation of a mask mandate. Governor Abbott removed the statewide mask mandate last week, and his order went into effect on Wednesday. And they're saying here that the mayor from Austin wants to keep masks until at least April 15th to avoid another surge of cases. They're saying now that Paxton told Adler and Brown they had until 6 p.m. last night to rescind the mask mandate. No dice. As far as I can tell, nothing changed as of 6 p.m. Came and went. The war of words escalated. So here it is. Texas Attorney General on Twitter is posting over there, says, Mayor Adler, Andy Brown, you and local health authorities have until 6 p.m. today, this was 2 days ago on March 10th, to rescind any mask mandates or business operating restrictions and come into full compliance with GA 34. Otherwise, on behalf of the state of Texas, I will sue you. People will kill each other over these masks. It's, as we can see, we're having some lawsuits, our first mask lawsuits that we've covered on this channel. Maybe there are others. This is the letter that was sent from Ken Paxton over to Judge Brown and Mayor Adler. It says, over the past 24 hours, Travis County City of Austin officials announced that local orders requiring individuals will continue unabated despite Governor Abbott issuing otherwise. It says here, there are no COVID-19 related operating limits for any business, according to the governor. In short, GA 34 has the force and effect of state law and supersedes local rules and regulations. The decision to require masks and otherwise impose COVID-19 restrictions is expressly reserved to private businesses on their own premises. It does not rest with jurisdictions like the city of Austin or Travis County or their local health authorities, nor do they have any authority to fine or threaten fines for noncompliance. We've already taken you to court under similar circumstances. You lost. If you continue to flout the law in this manner, we'll take you to court again and you will lose again. To that end, you and your local health authorities have until 6 p.m. today to rescind any local mask mandates, retract any public statements, and come into full compliance. Otherwise, on behalf of the state of Texas, I will sue you. For liberty and justice in Texas, from Ken Paxton, AG of Texas. So he's on one over there in Texas. I'm not even mad about it. Here it is. To be clear, the governor's authority exceeds that. So that's over from hotair.com. You can go check that out. Let's take a look at some questions here coming over from locals.com on this immigration issue. Here is one from Dr. Renal MD, who says, at Robert Barnes. Robert Barnes is not here. This is Robert Gruler. Robert Barnes, nice, very nice fellow. We had an interview with him recently, but he is another Robert. But I know who you're talking about. I think you're talking to me. He says, most of the public charge involves healthcare. I would challenge those who state, quote, healthcare is a right. If it is, when has a right ever been enforced on the backs of others? Does this right allow the government to make me work extra hours for free? What a slippery slope we are going on. Yeah, and that's from a doctor. That's from an actual doctor. Dr. Renal, the NY Renal MD in the house. Yeah, I mean, I don't know where that concept came from. I don't understand where all of these rights came from. Everybody wants a lot of rights to do a lot of different things that I don't know where they came from. Very curious. All right, but it's a good question. We have liberty or death. Our last question from this segment says, Mrs. Liberty is an immigrant. Thinks that Creepy Joe is absolutely wrong here. Yeah. You got a good one over there, Liberty. Doesn't understand how we are expected to accept the unilateral changing of the law by the president for the illegal alien, or why we are importing poor people when we have our own. She was wondering what law or laws the American citizen is allowed to break to tell the court, yes, I did that, but I am otherwise law-abiding. What law or laws the American citizen is allowed to break to tell the court, yes, I did that, but I am otherwise law-abiding? Well, this is going to be a good question, and I don't know what the long-term solution is going to be on this immigration issue. Now, I understand what Biden and his people are doing. Of course, they want to be compassionate, right? We talked a lot about immigration reform. We talked a lot about lifting people up and how awful Donald Trump was with all the kids in cages and on and on. Okay, so now they have rescinded a lot of the Trump rules. Now we see just this massive surge of people coming up. Why? Because the Biden administration created some pretty strong incentives to do that. Donald Trump created some strong disincentives, and Biden is creating incentives to encourage people to come across the border. And now when they get here, the question is, well, what are they going to do about it? If you recall, during the Trump administration, this was kids in cages. This was kids who were being locked up like animals, you monsters. But today, now it's just, what are they called? Temporary facilities. These are immigration centers, processing centers, and they've got all these nice little, fluffy phrases that they wrap around the same concept. And they're little centers are going to break if the numbers keep up. And so they're going to have to decide what to do with this. And how are they going to sort of approach it on the back end? Are they going to be sending people away at the border? Are they going to come to the border and just turn them back? Doesn't sound like that. It sounds like they're going to be able to come into the United States, be kept for a certain amount of time while their asylum claims get processed. And because there's nowhere to house them, they just get set free. They just get released into the United States. And the big question here, the big issue that a lot of people who are concerned about unbridled immigration happen to have is that, are they going to show back up to their court proceedings? Are they going to follow the process when there's really no incentive for them to do so? And it's going to be very curious as to where this goes. It feels like that they sort of are shooting themselves in the foot. They created a bunch of incentives. They've already demagogued the hell out of any solutions that other administrations have attempted to implement in order to stem the tide. And now they're going to have to deal with the consequences. And the American people are going to have to see what that feels like and how they like it. We can already see AG Paxton is trying to get involved here on this lawsuit and others. And I think Governor Abbott from Texas ordered 500 National Guards down to the border, which is like a blip. Right? It's basically nothing, but the states are going to have to start taking this stuff back into their own hands if they want to control their borders. All right. Good question. All right. So our last segment. Oh, we're talking about Ghislaine Maxwell again. Ghislaine Maxwell. All right. So this story, Ghislaine Maxwell is in hot water. Now she's running out of money in addition to all of the other problems that she's facing. So she is now set to sell her home, which she's not living in currently, to afford her attorney's fees, which are, I would expect to be massive. I was on another show, Sean Atwood's show, and we were talking about this, and we were sort of speculating about what her hourly rate for her attorneys might be. And I was saying it could easily be $2,000 an hour, easily. It could easily be more than that. I'd say I can't imagine in any world where it's less than $1,000 an hour. Spending a ton of money, and her attorneys are doing a ton of work. I mean, a ton. We've gone through the docket here on this show, and you'll notice that like every day they're doing something. They're always communicating with her, so they are racking up a massive bill. And it's funny that we were just talking about it because this story came out today. Now, she may have to sell her home. This came over from the WashingtonExaminer.com. There it is, WashingtonExaminer.com. It says Ghislaine Maxwell, the British socialite with ties to disgraced pedophile Jeffrey Epstein, will soon be selling her home so she can pay her legal fees, her family spokesperson said. The house is located in London's Belgravia district. The sale will be completed soon, said Brian Basham, spokesman for the family. Houses in the area have sold for the equivalent of between 3.6 and 11.2 million. One of Epstein's accusers, Virginia Roberts Guffrey, alleged that she was forced to have sex with Prince Andrew at this property in 2001 when she was 17. Member of the royal family has disputed the allegations. She's nearing a deal to sell the property despite her bank, Barclays, deciding to close her accounts in February, according to the Wall Street Journal. Her brother, Ian Maxwell, accused the bank of closing her account to protect Barclays CEO Jess Staley, who visited Epstein's private island multiple times when he was an executive at JP Morgan Chase & Co. So you see how deep the hole goes. We have no idea what Staley got up to with Epstein, but whatever it was, it's his problem, and he should not be taking his problems out on my sister. Staley is playing at Pontius Pilate with my sister's life, Ian Maxwell said, though a bank spokesperson rebutted the claim, stating, as a matter of course, the group CEO would not be involved in decisions to close accounts. And so we're going to go through, first of all, that's obviously a big problem for her. If she runs out of money, her attorneys stop working, and that's not good for her. So we are going to take a look now at her the response to her motion to get out of custody. So remember, earlier in February, she submitted her third bail motion, which is a request to get out of court, get out of custody, so that she can get back to preparing her court case. She's tried to get out. She originally submitted a proposition to get out of custody that included massive amounts of collateral, tens of millions of dollars, multiple properties, even giving up her citizenship in France and I think England, amongst other places, forfeiting her passports, saying that she's going to get on an ankle monitor, communicating with people. They even went so far as to appoint a federal or find a former federal, I think, judge and prosecutor to monitor her bank accounts so that she could only withdraw at any given time $5,000. Anything more than that would be subject to oversight from the federal judge, former federal judge, and a former U.S. attorney, a former prosecutor. They're both going to be monitoring this. I mean, this is massive. I mean, this is the type of it's one of the most expansive attempts to get somebody out of custody that I've ever seen, and they're on their third attempt now. Trying again. So they submitted that prior request. The government is now responding to this, and they're saying, no, you're not going to get out. Here she is. This is from electronic mail, electronic court filing, document 165. This was filed a couple days ago, March 9th. And it says here, Dear Judge Nathan, the government, I'm not going to read all of this. There's a lot of text in this, but we're just going to kind of skim through it. The government respectfully submits this letter in opposition to the defendant's number three, motion for bail that was submitted back on February 23rd. We've had extensive briefings. We know that she poses a serious flight risk and that no condition or combination will secure her appearance in court. They're saying if we let her out, she's gone. There's no way we're going to get her back in court. Doesn't matter what she promises. Doesn't matter if she gives you the house, gives her the passports, whatever. If she steps foot out of this prison, she's gone with the wind. On December 28th, after the defendant renewed her first motion by restating her prior arguments and giving a more significant and specific bail package, this court concluded she plainly poses a flight risk and denied the release. They appealed again in 2020. Now they ask a court yet again to consider its decision. They proposed 2 additional bail conditions to supplement the bail package previously considered and rejected. For the reasons set forth below, should be denied. Number 1, why should it be denied? The court does not have jurisdiction to grant the third bail motion. The defendant has appealed that December opinion to the second court. So they're talking about, which I didn't even realize that they appealed that. That's insane. They're talking about the fact that because that second motion is being appealed, that this court can't consider any current pending motions until that other matter is resolved. We sort of saw this issue in the Chauvin case that we've also been talking about. That third-degree murder charge was appealed. Both sides didn't want the trial to continue because the court really didn't have jurisdiction until it came back down. Judge went ahead anyways, and then they got that stuff sorted out. So the prosecutor here is also saying, no, we can't even argue this, can't even decide on this because they're already appealing attempt number 2 up to the Court of Appeals. Second, even assuming that this court had jurisdiction to grant the latest bail application, the court should adhere to its prior rulings because she continues to pose an extreme risk of flight, and the additional bail conditions do not justify the reversal. So they're saying this should be denied. A little bit of background here. Court's document in December 16, 2020. Court originally denied it. They submitted a substantially larger bail package. Court denied that. January 11th, they filed a notice of appeal to the Second Circuit. February 23rd, then, about a month later, over a month later, they submitted the third bail motion package. And here's what they wanted to do. They wanted a renunciation of the defendant's French and British citizenship. So she's going to give up those passports and the citizenship entirely. And I'm going to show you, we actually have a statement from the French that detail how this works in their country that was attached as an exhibit to this motion. Number two, they want to place a portion of her and her spouse's assets that are overseen by an asset monitor. So that was the two individuals that I was talking about that are going to oversee all of her assets. They're going to dump everything, all of the assets from all over the place into one bucket, and they're going to put a couple people in charge of monitoring that. The court, as they said, does not have jurisdiction to grant the third bail motion. So you can see a lot of this stuff is just sort of law as a general matter, the filing of notice, blah, blah, blah. This is all procedural stuff, a lot of case law here, stuff that's not particularly interesting, but we can just kind of skim through this. Then we go on, subsection number 3, the court should not reverse its prior well-reasoned and thorough bail decisions. Even if this court had jurisdiction to grant the bail motion, the motion should be denied. Court has already twice made the determination that the defendant poses a risk of flight. In particular, the court has found that the charges carry a presumption of detention and are serious and carry lengthy terms of imprisonment if convicted. The evidence proffered by the government, including multiple corroborating and corroborated witnesses, is strong. Defendant has substantial resources and foreign ties, including citizenship in a country that does not extradite its citizens, and the defendant, who lived in hiding and apart from the family to whom she now asserts important ties, has not been fully candid about her financial situation. So yeah, this has been something that has been interesting, right? She was already in hiding for a long period of time. And one of the principal arguments that was in her underlying third motion was my husband and my family, and I want to get connected with all of these people, but I can't because I'm in custody. And that's something that's pretty common, but the prosecutor here, I think, is rightfully pointing out, well, you didn't care about him before you got taken into custody, so why do you care about him so much now? In seeking bail for a third time, the defendant's motion rests principally on 2 additional bail conditions. Neither of these conditions, and those 2 conditions were, of course, giving up her citizenship and dumping the assets into a monitored bucket. Neither of these conditions will reasonably assure her appearance in court. Neither outweighs all of the other factors. Moreover, the court should reject as premature the assertion that her pretrial motions have weakened the government's case. The motions have not been adjudicated, and thus the reasons set forth in the opposition memorandum, the defendant's motion, have no merit. In short, all 3 of the relevant Bail Reform Act factors, the nature of the offense, the strength of the evidence, and the history and the characteristics of the defendant continue to weigh heavily in favor of detention, and the defendant's motion does not present any information that warrants a revisiting of the well-reasoned and detailed prior decisions. So let's take a look. This is a long opinion. Let's take a look if there's anything else worth covering. We have the applicable law, so they're going to tell us what the law is. We got that. Defendant's motions rest on 3 arguments. Renounce the foreign citizenship, claiming that this eliminates the risk that she will flee from prosecution. Second, offers to place some of her assets in a monitorship. And third, claims that her pretrial motions have diminished the strength of the government's case. So let's take a look at each one of those. Here we have the defendant's willingness to renounce her foreign citizenship. So what if she does give it up? She contends that she has materially strengthened her proposed bail package by offering to renounce her foreign citizenship if the court so requires. She claims that such a renunciation will eliminate any opportunity for her to seek refuge in France and the UK, or remove any incentive the court and government believe she may have to seek refuge in those countries. The defendant is wrong. That she is, quote, willing to renounce her citizenship would do nothing to prevent her from fleeing and fighting extradition once abroad. It does nothing to diminish the risk that the defendant could choose to flee to another jurisdiction altogether, including one with which the United States does not have an extradition treaty and from which extradition is impossible. The court previously found the likelihood that the defendant would be able to frustrate any extradition requests weighs strongly in favor of detention. Motion provides no basis for disturbing that finding. We go on to number 3. The willingness to renounce the citizenship is an offer with unclear validity. We're going to talk about that. The defendants have offered no authority for the proposition of her renouncing foreign citizenship, whether that would have any impact on the extradition proceeding. So they don't even know if she can do it. They don't even know that if she did in fact renounce her citizenship, whether that would ultimately preclude them from not extraditing her. And so let's go through that. Here is subsection 2. They should reject the proposed monitorship condition. So this is the monitoring of the bank account. They're saying that she's going to place a portion of her and her spouse's assets into a new account that will be monitored by a retired federal district court judge and a former U.S. attorney who will function as the asset monitor. They're going to have co-signing authority over the account. The proposed condition, the details of which are vague, is insufficient to assure that she appears in court. So do you think that she really would include all of her assets, everything, into this bucket, truthfully? Does she have anybody else who might be able to lend her $1 million in order to escape the country? I have a hard time believing that everything would go in there. And lastly, we have the defendant's pending pretrial motions have not diminished the strength of the government's case. So this is based around the idea that they're saying that they've been doing a lot of work on the case. They've been submitting motions after motions after motions, and that is going to weaken the case such that this justifies her, supports actually a not guilty verdict, right? It supports that there is no likelihood of criminal conviction here, which, of course, if they have a weak case, then that goes against the elements of holding somebody in custody. It goes against the nature and the context surrounding the underlying offense. And so they're saying because the case is getting weaker, there's sort of an inverse relationship there. The stronger the case, the less likelihood of her getting out. But if the case is weaker, then there should be a stronger likelihood of her getting out. And the government just says, no, that's not we're not going to do that. It says here, numerous substantive pretrial motions now before the court amply challenge the purported strength of the government's case, but they cannot merely point to the sheer volume of briefings that she has filed to suggest the strengths have been diminished. And so the prosecutor even knows this. I've been saying it. I've been saying that they have been filing a ton of stuff, and they're pointing this. Merely the sheer volume of the briefings, that doesn't mean anything. To the contrary, the government has set forth in detail in its memorandum the pretrial motions are entirely without merit. In any event, it's premature for the defendant to claim that her pretrial motions, which have not been adjudicated, have altered the court's original determination that the government's case is strong. Signed here by Maureen Comey, Allison Moe, Laura Pomerantz, all out of the Southern District of New York. And so I think that the deadline for Ghislaine and her attorneys to reply. So remember, you file a motion, you get a response, and then the moving party gets to reply to the response, and that's the end of the conversation. And so I think their reply is due by Monday. If I can, I might be off on that, but it's coming soon. And so next week, we're probably going to see a ruling on this third bail attempt. I do not think that it is going to go Ghislaine's way. This is kind of an interesting case because truly, we talked about this yesterday with Chauvin. And we talked about this yesterday with maybe not yesterday, but previously in the week about Jacob Chansley, who is the QAnon shaman who is not being granted bail either. He's got no criminal record. The judge was talking about him using drugs as evidence of criminality. The judge also said that because he committed a crime that he's being held for, that fact alone makes it likely that he's going to commit another crime, something like that. Asinine opinion, one of the worst opinions I've read recently from a judge in a federal court like that, but whatever. And it's an interesting thing here because we were talking about this on Clubhouse last night. We were saying that, well, Rittenhouse got out of custody. He had a $2 million bond. Chauvin got out of custody. He had a $1 million bond. Other murderers get out of custody. Ghislaine Maxwell didn't murder anybody that we know of, right? Some sexual assault crimes. Okay. Heinous, horrendous, awful, reprehensible conduct. But other people got out of custody and they killed somebody. Why wouldn't she get out of custody? Well, maybe she should. Maybe the factors support legally her getting out of custody if you compare it to other defendants who have been similarly situated. But if I were the judge, I don't care what the law says, right? You go through and you do your analysis, and she does not get out of custody regardless of anything because of the simple fact that the risk of her flight is so high, so massively high, that basically anything that they propose, I don't think the judge is going to consider that at all. So here is the last little bit from France. So this is what they say. So they sent a letter over there. This is the Ministry of Justice, the Directorate of Criminal Affairs and Pardons. This comes from Paris, March 9th. His Honor and Keeper of Seals, the Minister of Justice, which is pretty awesome. A Keeper of Seals. Sounds like something out of a fantasy novel. From the Department of Justice, as I hereby inform you that in France, all removal proceedings and conditions are governed by Article 696 of the Code of Criminal Procedure. That code provides the French government is able to remit to foreign governments upon their request any individual who is not a French citizen, who is subject to a lawsuit brought on behalf of the requesting state, and who is subject to a sentence passed by the court of said requesting state, and who is located on the territory of the French Republic. So if you are not a citizen, we're going to wrap you up and you can go. We're going to send you overseas. However, Article 694-4 expressly specifies as follows: removal is not granted when the individual claimed to have French citizenship, said citizenship having been assessed at the time of the offense on the basis of which removal is being requested. Removal is not granted for that. And so citizenship having been assessed at the time of the offense. Well, she had citizenship at that time. She has citizenship now. She hasn't given it up yet. So she's had it at the time of the offense on the basis of which removal is requested, whereby the fact that the wanted individual is a French national constitutes an insuperable obstacle to his or her removal. As long as said nationality is assessed at the time of the offense was committed, any loss of nationality subsequent to said offense has no bearing upon the removal proceedings and shall not supersede the said assessment of nationality signed off by Philippe, head of the International Criminal Assistance Bureau. So what they said is, if she was not a citizen, we'd send her right back. But she was a citizen at the time, therefore, we're not sending her back, even if she renounces her citizenship now. Sorry, we're going to consider it at the time of the offense. So if she left and fled to France, according to their own specialized criminal justice subdirectorate, Philippe something, she doesn't come back to the States. So this judge is not going to let her out of custody. We have some questions coming in from locals.com on our Watching the Watchers group. Says Paula MK, if Maxwell is selling because she's running out of money, how does she expect to use all of that collateral as bail? Also, is this a ploy to get out of saying that she no longer has the means to flee because she's supposedly running out of money? Yeah, probably. I mean, I think this is probably theater, right? If Epstein was worth several $100 million, a lot of that money still floating around. I'm sure she's got access to mounds of cash. And this is a nice little liquidation of certain assets in order to accumulate those assets that she can expend towards her legal fees. But does anybody really think that she doesn't have access to millions of dollars? I don't. We have News Now Wyoming. Last question of the day says, Rob, do you think if she hadn't made them search for her when they arrested her, that would have changed her chances for bail? If I remember right, it took them a while to locate her after the warrant was issued. Yeah, it actually might have, right? If she knew, as soon as she knew that they were looking for her, if she just hired an attorney and said, all right, look, make contact with them, negotiate some bail conditions, negotiate release conditions for me, she might have been able to negotiate those things out. And I don't know if she did that. I don't know if her attorneys attempted to do that or what the underlying investigation looked like that ultimately led to her capture. But certainly, one of the things that judges look disfavorably upon is when you are fleeing formal court process, when you're fleeing being served, when the court has summoned you to be a part of the process and you just leave. Court does not like that. Not at all. And here, because she was running around the country, sort of in hiding for a long period of time, the judge may look at that and say, no, you were not forthcoming. You're saying now that you're going to come back to court, but you didn't at the first time. So how are we supposed to believe you? And I know you're going to give up all this stuff, but do you think that we believe that you don't have any assets to get out of the country? And you said you'd give up your French citizenship, but the French don't even say that that matters. So I think the judge is just going to deny this one again, and she's going to remain in custody. But as you can see, they are filing these motions, in my opinion, to set a very strong foundation of appealable issues. They're going to say that because she was in custody, as you can see, they're already appealing this to the the Court of Appeals. If they don't let her out of custody, they're going to make all sorts of due process claims, all sorts of procedural violations, that she doesn't have the opportunity to consult with her attorneys enough, that she's getting treated inappropriately, sort of almost an equal protection claim, that other prisoners are treated one way. She's being treated differently because of the severity of her claims. And so they're just laying the foundation for this stuff, that when she goes to trial and gets convicted, everything's going to get appealed again. And they want to get her out of custody so that, well, she's not in custody. What happens after that, who knows? But I wouldn't hold my breath on her getting out anytime soon. I think that's the right call. All right, so those questions came over from locals.com/watchingthewatchers. I want to thank those of you who have shown your tremendous support for the show. Big thanks to Miss Faith Joy and to Ma Fox in the house. Thank you both. We've got Liberty or Death who chimed in today, along with Miss Liberty or Death. Good to see you both. Thanks for being here. Jen McClellan, we got Saline Sal. Who else did we have chiming in? We got Scuba Babe. We got Chairman of the Board. Sharon Quidney was in the house. Saw her today. We got Chris Wiseman usually in the house. We got Danny Girl, Realtor Patty. Where's Paula MK? There's Paula MK. We've got The Mariner. We have Britt Reed, Moleface. We have Abby Lou Jack. We have Echo House. We got Get Some Skates, See the Veil. We also have Bumalickit. I like to say that one. We got Nord Sven. Then we have a new individual who joined the group over here. Welcome, Bulletproof number 7. Great to have you. Yesterday, we had some other people sign up. Jared Harding, E2The. We had Danger Mouse Girl. We've got Phantasmagloria. We got Remark number 2. We have Norovira in the house. At Zuck. Zuck's in here as well. And if you're not on Locals, well, what the heck are you doing? We're having a good time over there. There's a lot of stuff you can get as well. Get a copy of my book. It's called Beginning to Winning, How to Fight Your Case and Succeed in the Criminal Justice System. There's a free download in PDF version over there if you want to grab a copy of that. We're also going to post a copy of all the slides there. A copy of the impeachment party documents are there. Grab my existence system if you want it. Free little template here that you can use and make your own personal productivity system that I use every single day. We have links that we share throughout the day, and there's great people who are there as well. We are going to start posting clips of the show over there. You may have seen that this afternoon. Locals is telling us that they want us to post our content there. Well, why? Because they're building some cool features in terms of playlists and some sort of TV broadcast applications that you can use to play your content elsewhere on your devices and on your TV. So you're going to start to see some content being posted there. If you don't like the notifications, just go into your settings, turn those off, and you won't get bothered so much. I sort of detest endless notifications. So just giving you that warning. We're not going to try to notify you or spam you if you're a member over there, but just keep in mind that we're doing that for the long-term building of something better that Locals is going to be unveiling further down the road. So great little platform, a lot of fun people over there. It's at watchingthewatchers.locals.com. You can support the show, meet some great people, and have some fun. All right, so that's it from me. Lastly but not leastly, I want to tell you that I am a criminal defense attorney, as you can see right here with the R&R Law Group. We are a criminal defense law firm. That's all that we do. We love to help good people who have been charged with crimes find safety, clarity, and hope in their cases, but beyond that, in their lives. We help people who've been charged with anything and everything. Things like even traffic violations, but things like DUIs, domestic violence, disorderly conducts, assaults, urinating in public. Sometimes that happens, and we help people through that. So if you know anybody who has been charged with a crime in the state of Arizona, we would love a referral from you. We'll make sure that we help them, that they come to our office and leave better than when they came. And we got a great team of people. We offer free case evaluations. And so a referral from you would mean the world to us. That is it from me. We are going, any other last minute show notes? Nope. We are going to hop on Clubhouse here for a little bit. So the link is in the description below. Come on and join us. Otherwise, I will see you next week. We'll be back here. I think it's the same time for most of you. We have daylight saving. I got corrected that there's no S at the end of that. Daylight saving time. I think that's starting this weekend. So I think it's the same for everybody, but I think I'm starting earlier on Monday. So I think for me on Monday, I think it's going to be 4 p.m. Arizona time, 4 p.m. California time, still 6 p.m. in Texas. We're going to figure it out. We'll let you know. We'll let you know. Faith is typing it right now. All right. She's notifying me about what the times look like. So 4 p.m. Arizona time, which means it's going to be, I think, the same for everybody else. So you don't have to change anything, but we got to change. It's the worst. Why do we do this? It's still 7 p.m. Eastern time. It's still going to be 6 p.m. Central time, 4 p.m. on the West Coast. Ugh, gosh. Can we just get rid of this thing already? All right. So that's it for me, everybody. I'm going to see you next week when I see you. Same time for most of you. I'm struggling today. We're going to get out of here. We're going to jump over to Clubhouse. Everybody have a wonderful, very nice weekend. Sleep well. Eat a lot of good food. Unplug from politics. Be with loved ones. I'll see you right back here. Same time, I think. Same place on Monday. Have an awesome weekend, everybody. And bye-bye.